Stay tuned for Legal Straight Talk.
Is this reality? No, I don't feel okay. I need my kaleidoscope of colors to lead the way. I'm riding in my car and I'm coming on around the bend. It's a chase, this twisted race. I'll be on top again. I'm not gonna let you take me down. It's gonna be the whole 9 yards or nothing.
Welcome to Legal Straight Talk. Thank you for joining us again. My name is Brett Harrison, and today again for another discussion on the lemon law, we have Anthony Ballato, who we're fortunate enough to have back. Thanks again.
Good evening. Nice to see you.
Okay, let's pick up a little bit, because
Okay.
I have a lot of things going on in my head now after our conversation. It made me think a lot about different things. But what cars, let's say you have a situation, a used car or a new car, that what doesn't qualify under the lemon law?
Okay, so as I said the last time we met, the first analysis that we try to go through, since the lemon law is a consumer's best friend, if you will, for the reasons that we previously discussed, it's quick, it's inexpensive, and you get a good remedy out of it. We first go through that analysis and we think about, well, does your car qualify or not? And these are the different things that will come in that kind of knock the consumer out of the box, and then we have to think of other remedies. So first thing is, if they bought a used vehicle and it was purchased before 1983, when the New York statute or lemon law was enacted, well, that doesn't apply. The next thing is, if the used vehicle had 100,000 miles or more at the time of purchase, that's the end of the lemon law. If the vehicle cost $1,500 or less, that doesn't apply. If we find out that the vehicle is used primarily for business rather than personal use, again, no lemon law, because it's a consumer statute.
When you say primarily, what does that mean? More than 50%, or is it based on miles?
If it's used 50% or more, according to some of the case law, for non-personal use, for any kind of business use, and it doesn't mean that it's used as a taxi cab or used as a landscaping service, but that, unfortunately, even if a person depreciated it on their tax returns for more than 50% of business use, like maybe you or I, and our accountants would put down one of our vehicles if we leased or bought it and we had it for business use, then that doesn't apply. And then other vehicles that are defined under the vehicle and traffic law as either a classic car or an off-road vehicle, or even if a consumer, not that most people would ever think of doing this, but they rent their car out to someone else, all of those things don't apply. Then we got into limitation periods. If a vehicle was purchased 4 years or more from the date that we can commence an action or proceeding, again, no more lemon law use. And then there are some other things that may, for example, unfortunately, New York, which is in a minority of states, does not apply certain things like the Magnuson-Moss Warranty Act that we discussed earlier, federal statute, to leased vehicles, only purchase vehicles. So now we have
So if you lease a vehicle, this lemon law does not apply?
Nope. The lemon law applies in New York to purchased or leased vehicles.
Or leased, okay.
But unfortunately, New York, in a minority of states, does not apply the Magnuson-Moss Warranty Act, which is another very favorable consumer statute to vehicles that have been leased.
When you say,
Which is odd, because New Jersey, right across the river, has the opposite result, and they apply it to both leased and purchased vehicles.
oh, that's unusual. Usually our sister state or cousin state, we usually are lockstep.
Yeah, usually it's California that does things differently,
Yeah,
right?
that's, when you say Mag-Moss, because I
Yes.
can't pronounce the whole
Okay.
thing, what is that exactly?
That's a federal warranty statute that basically provides that if a consumer of a consumer type of product, not just automobiles, they could be refrigerators, washing machines, any type of consumer product, is given a written warranty that the seller or the manufacturer of that consumer product must honor that warranty. If not, then the statute comes into play, and what's most important, provides to a successful consumer attorney's fees are recoverable. That's what's known as a fee-shifting statute that gives now the little guy, and we talked about
Right.
David versus Goliath the last time, the power to now go into court, because at the end of the day, if they're successful, they can recover attorney's fees, and in some cases across the country are a multiple of the amount in controversy. So you could buy a $15,000 car and you could be awarded a $75,000 legal fee, because that's how long these things can take.
And all the efforts and the work.
Correct.
That'll stop, hopefully, Goliath from,
If you have enough of those decisions in your state, that should then encourage manufacturers or dealers to settle and not deliberately drag them out.
when you're going to use the MAGMAS statute, and now you're dealing federal,
Okay.
I like to call it, would you, and from a legal standpoint, you say, would you do any forum shopping? Simply meaning, could you see which state is more favorable, let us say, to, or better case history, better, however they apply the
Okay.
statute? Would you say, maybe I should bring this in Connecticut or another state?
Well, let's first talk about, if I may, why we want to have a MAGMAS or Magnuson-Moss warranty case using the federal statute in the first place. That may be because, unfortunately, for one of many reasons, particularly if the vehicle was used for business use, that the New York or state lemon law doesn't apply. So if I have someone come to me that's a landscape contractor,
Right.
and they bought a new expensive pickup truck, and it clearly qualifies for everything but for it's not primarily personal use, the
Right.
lemon law goes out the window in New York, but we could bring an action, let's say in Supreme Court, under the breach of warranty, under the manufacturer's warranty, under some other things, and also the Magnuson-Moss Warranty Act, seeking to recover attorney's fees.
See, now, I think what's interesting is, that's federal, the...
It's a federal statute, but we're bringing it in state court. You
And the
could
reason-
also bring it in federal court if you want.
But there are some advantages in federal court, because the case, for lack of a better, proper phrase, won't be strewn around as much, and they're pretty strict in federal court.
Unfortunately, though, in those cases, they
They're not-
require two things. One, either diversity of citizenship, or B, federal question, which, and I'm sorry to get too technical here, but since that's a federal statute, you now have the federal statute of the federal question, but it has to involve a controversy of $75,000 or more. Now you're getting into pretty expensive cars, and most of my clients or consumers, their cars are under $75,000, so we're not getting into federal court. So that's okay, we'll go into state court.
Now, you like to use the MAGMAS statute sometimes because now you can also get attorney's fees,
Correct.
which now
Which-
changes the game.
Well, you can get it under the state lemon law as well in New York, only if you go to court, not if you stay in arbitration, because that's the interpretation of the statute by our Attorney General who runs the program.
So a lot of times what you might find, inexperienced, whether it be attorneys or people that bring a case into court, not realizing that one little quirk, which is, did I use it for business? You know, they could lose the case just based on that if they don't sue properly, have the right
That-
cause of action.
That's correct, and more importantly, if they let the 4-year statute of limitations run out, now they're in big trouble. But you asked before about form shopping different states, and, you know, there are, most times, you only have jurisdiction in one case. So, for example, a client calls, they bought a car in New York, it's registered in New York, they live in New York, and they say, the New York statute's not good. I heard about these great laws over in Wisconsin where I can get treble damages. You can't go to
But
Wisconsin for
sometimes,
that.
but it's not unusual, let's say you're shopping for a used car, even some new cars, where you may get a better deal if you're in New York or Connecticut.
There you go. So
Now we have a little play, do we not? Or is it where you buy the car?
well, if you have a situation where, let's say, a New York resident purchased a car in, pick another state, California, all right? Now they purchased a new car in California but registered it in New York. They have a choice of New York or California.
You know, let's say you're buying an because this also covers motorhomes and RVs and motorcycles. Am I correct?
Everything but pretty much boats, airplanes, and off-road vehicles.
And trains.
Well, those two, yeah.
But
People are dying to get boats covered under the lemon law. I get those calls, and I only wish the lemon law applied to them. Magmoss
Listen,
does, but not the lemon law.
because there's guarantees, and just so people understand, when we talk about warranties and so forth, we're really talking about you as the consumer have relied upon the warranty that this would be fixed, or that the everything but the boat, the motorcycle, the RV, the car was in a certain condition as either. Now, does this come into play as advertised? Because a lot of people buy stuff via now the internet, whether it could be eBay, it could be, there's a whole host of things.
You know, you brought up, and I don't know if you even realized you did, a perfect segue into what's known as the Uniform Commercial Code, which is another statute
That's like a scary term. When I
It's-
hear that as an attorney, that means it's a lot of books.
Yeah, it can be, but it's uniform throughout the country, except maybe Louisiana, because, you know, they got their own civil code there, all right? But for most of the states, it's there, and this is what's interesting under the UCC. If the seller is a merchant, which is typically the case, some kind of a car dealer in this state, that they sell 3 or more cars per year, that's all. You don't have to be a licensed dealer, just that you sell 3 or more cars per
You're
year.
deemed a dealer?
Or you're a licensed dealer, you're deemed a merchant under the UCC, which is Article 2 for the sale of goods, and there you have implied warranties. And one of the key warranties is
Explain what it-
implied for its ordinary purpose, or the implied warranty of merchantability. So when someone buys a car...
Put that in English.
Yeah, that's what I'm doing. When you buy a car or a
Right.
vehicle, what do we intend? That it starts, that it runs, that it brakes, that it steers,
It's safe,
that it does,
as you call
that
it.
it's safe, that it does all the things that a car is
As
supposed
well
to
as
do.
what's advertised?
Well, those now become representations, which you can hold the dealer or
You
the
could say, well,
seller.
I, as the consumer,
You can
I
hold them-
relied on the representation.
You can hold them now to a higher standard. All right, so if they're making representations, let's say for a used car, and they say, this car is mint, this car is accident-free, this car is a cherry, it's never been repainted, on and on and on.
But do you have an obligation, because what are the, you can go to Carfax, all these things. Do you now, as the consumer, have an obligation to say, well, did you check Carfax? Or you can rely on that representation, because they're putting it out there to entice you to sell. I mean, I guess that would be...
Again, excellent question. We've all heard of caveat emptor, or buyer beware, which under the common law says to the buyer, you better do some due diligence before proceeding. Now, I'm not aware of case law that's gone to such an extent that puts the burden on a purchaser to run a Carfax or an auto check, which is the other big company.
Well, do you have to
that
hire a
provides reports.
mechanic? Is it implied that you should be hiring a mechanic?
I believe the case law provides, in this state, that all the consumer has to do is not do those extraordinary
It's a lot
things.
to do.
But no, just ordinary diligence. So if you walk around the car and
Okay.
something's obvious, like there is a huge dent in the fender, or the car, when you drive it, it drives crooked, that you should think, I think this was in a major accident and the frame is damaged, but you're kind of overlooking that. You
Right.
can't later on say, I was defrauded and it was covered up. But if the dealer does not give a Carfax, the consumer's not obligated to do them itself. And furthermore, Carfax and AutoCheck are not the Bible. They're not perfect. There's a lot of things that don't get reported, or
Not every not every accident gets reported.
or they get reported late. And also, I'm sorry to say that I get calls where people have been given altered Carfaxes, that they play with the VIN numbers or what have you, and they're giving them a Carfax from another car, or they show it to them real quick, and then they take it back, and it's not the Carfax.
Or they
from
get a
that
different
car.
one in their, they're shown one thing, and in their packet, they get a different one.
That's
Now,
correct.
let's say classic cars. Okay, now you're talking a whole different field. Now, would you say
Now
that...
you're talking my field. I love
Uh,
classic cars.
Let's say classic cars. Now, is it expected if you're going to buy let's say a 1940 car or a Ford or something, old car, a Packard or anything like that, is it reasonable to assume the person who's buying that car is going to have that vehicle checked out by a mechanic? Is there that expectation or that assumption?
That's a rough question, and really due diligence is highly necessary when dealing with classic or collectible cars. And there we're going to go back to what you said
That's a
before
higher
about
standard, I would assume.
representations. That's where the representations are important, because if there are very little representation, such as when you go to an auction and the car rolls across the block and they'll say, this is a 1957 Bel Air convertible, and they say no more. They don't say that it's matching numbers. They don't say it was never in an accident. They don't
Right.
say that it was owned by some famous person. You can't really hold them to a standard. And also, you got to read the fine print in, let's say, the auction catalog as all the disclaimers. You have better protection if, let's say, you bought off eBay or some other website where there is a list of written representations about the quality or the characteristics of that vehicle. But still, due diligence is you should hire an expert to
Right.
check it out, because, we have to distinguish between having rights, or what attorneys will call causes of action, and being able to economically litigate them are two different things. So
Right.
you can have great claims, but if it takes 4 years in court and $50,000 or more on a $20,000 car, it's not feasible to proceed.
But sometimes people want to start an action and hoping that, you know what, as soon as I start the action and serve them, they're going to say, all right, what is it going to take to settle? And it doesn't always work that way.
No, it does not often work
And then
that way.
often, you're the bad guy as the attorney.
Yeah, and it depends, because if you're dealing with a dealer, they may have insurance that may cover them, or they may be on an annual retainer with a particular law firm that's going to defend every claim, or they may have house counsel that handles all of these cases. So it costs the dealer next to nothing.
Now you brought up an interesting point, that I'm just thinking about. You said some of them may have insurance.
Correct.
Now, is it a consent policy, which simply means that the dealer has to consent to any settlement, or can the insurance? Like in a malpractice claim,
That's gonna
depend on individual
depend
policy?
policy to policy, and I've had cases where the cost of defense is an offset on the policy. So one case in particular had $100,000 coverage, but the defense costs were eating away, and unfortunately, in that case, the defense firm made a mountain out of a molehill, if you will, or made a federal case out of it, as they say, and deposed everybody that they could think of, and interpleaded in 3 different sets of cases until they burned up the whole $100,000 of insurance, and then said to their dealer client, well, now you're on your own. And guess what? That's when the case settled.
That's abusive.
That is. It was disgraceful what happened there.
Now, recently I was reading some cases or some complaints. There are a lot of cars that were from Sandy that other people, dealers, whatever, are now selling them. What causes of action, and what can you do? What are your rights?
I'll be happy to share with you my observations, and
It's relatively new at this point.
and being a
for that.
Superstorm Sandy victim myself, and having the ocean come through my own house, I have a lot of sympathy for these folks. And I had assumed that within months after that storm, that since 250,000 vehicles were reported substantially or totally damaged, and maybe hundreds of thousands more partially damaged, these things were going to be popping up real quick. Well, there was like a 2-year lag or so, because it's only in the last few months that now I'm starting to receive more and more calls from people who have purchased cars, not just from individuals, but from reputable car dealers that obviously, to a mechanic, after inspecting them, were flooded cars because of the degree of rust and corrosion even inside the vehicle.
Now, the average consumer isn't expected to notice that.
No. And by the way, dealers, and the scrupulous ones are expert in covering this stuff up, whether it's repainting certain
Shine it
components,
up.
replacing the carpeting, doing air fresheners, all sorts of things on vehicles that maybe won't show up on Carfax or AutoCheck because there was no insurance to cover a flood at the time.
But what's interesting? It reminds me of what happened with, I think it was it Pinto? They figured, you know what? If we sell 1 million of these cars, or in this case, 10,000 of them, and only 5 people complain, we'll pay out those 5. And what they did with Pinto was very similar. They figured out from a cost-benefit analysis that if we sell 2 million of these vehicles and 5 people either get seriously hurt or pass away, we'll deal with those claims because we'll make more by selling those vehicles as opposed to fixing the Pinto for whatever it was, $10, $20 a vehicle. They figured that would cost more to replace everything, this one piece on all the existing Pintos than it was to possibly deal with lawsuit.
That's correct, and that's happened in case after case over the years with different manufacturers. And you're right, probably now with the Sandy flooded cars. Imagine a dealership might have millions of dollars of inventory, and Sandy comes along and floods their whole lot, and they have no coverage. They might be, scraping by to survive and trying out of desperation. And of course, this is what a lot of fraud cases come from. Desperate times invoke desperate measures, right? And cause what were otherwise honest folks to become dishonest just to survive themselves.
But you also have people buying in mass. Let's say they go to a deal. We'll take 300 of those cars that you've got, but the real value, if they weren't damaged, is $3 million. I'll give you, you need to get them off your lot.
Okay, so
I'll give you $1.2 million, and you hope. So now these people are buying those cars in a large amount, and then reselling them, fixing it up, spit shining them, or whatever they do to make it look pretty, shine the tires, air it out, like you said, replace the carpet, which is so cheap. No, they bought it at such a discount, and now they're selling it at a premium.
Right, so let's talk about now, what does the consumer do when they have a
What do they
flooded
do?
car? Well, interestingly enough, and it's a bit of a shame, when you take those kind of cases that qualify under the New York used car lemon law to the Attorney General's office,
Right.
They have a hands-off policy, and they say, whoa, wait a minute, this is a flooded car, you need to go to court or go to the Department of Motor Vehicles.
Why
And then
them? What is
I
they? What is it?
I guess it's because of their caseload that they're trying to, lower their caseload. I don't want to get into too much why, because I don't know their
So I got to
policy.
go to the DMV and look up at the ticker saying D6. I have to wait another 20 minutes.
No, worse than that.
I mean, what do you do there?
It's worse than that. You can't just go to the DMV office and they're
It's a
going to help you.
specialty office?
There is a special office up in Albany
So you gotta send
for
the stuff.
consumer complaints on their complaint form, and then you might get someone up in Albany that doesn't appreciate the devastation of Hurricane Sandy, and they look at it and they say, wait a minute, this car qualifies for the lemon law, you should go to the Attorney General's office, and 2 state offices are pointing people back to one another, and it's almost, I hate to use the analogy from like the Wizard of Oz, where they're telling Dorothy to go get the witch's broomstick, and she didn't need it the whole time, they're just giving people a runaround. But let's get into now, what can you do? Well, there are statutes and there are laws that have a lot of meat to them here. One is in New York what's called deceptive trade practices under the general business law, and that provides for attorney's fees. Also, under the Uniform Commercial Code, we talked about those implied warranties. That doesn't provide attorney's fees, but common law fraud does, as well as punitive damages.
But how long is your fraud and any type of intentional act is probably not a 4-year statute? Or is it a 6-year because it's a contract?
That's very interesting. Under the Uniform Commercial Code, if you're suing for breach of warranty, it's reduced to 4-year statute of limitations.
Oh.
Under Mag Moss and under the New York lemon law, it's a 4-year statute of limitations. Those are for those causes of action. But if it's fraud, now you're going out to a 6-year statute of limitations.
Or is it, let's say it's past that, but is it ever at when you could reasonably have discovered the fraud?
Yes, you can in cases of active concealment where the seller knew or should have known that there was a cover-up, but the purchaser did not, you might have what's called a tolling of the statute of limitations to the time when the purchaser knew or should have discovered that there was a fraud. But that all starts to get very complicated. I'd really like to see those cases brought within the 4-year period from the date of delivery. And I have to tell you something, with a flooded vehicle, if you don't know within 4 years, you know what? Then maybe it was repaired pretty well.
What else? What can you do with these vehicles now? When now you have to pretty much. How does the lemon law does or doesn't apply to Sandy now?
Well, if it meets the qualifications under the lemon law, such as the dealer didn't repair it within 3 repair attempts, or it was more than 15 days out of service, my opinion is lemon law applies. You should be entitled to relief. Unfortunately, the folks in Manhattan who are administrating the lemon law and assigning it out for arbitration are taking some sort of exception and saying if it's a flooded vehicle or it's a fraud case, we want you to take it to court. We don't want you to go through our arbitration program. And that's a real problem, where my argument with them is, you're the administrators of the program. You're not the finders of fact. You're not the arbitrators. And you should not be basically summarily dismissing people's claims before they had a right to a hearing.
It seems like it's against the whole concept of consumer protection.
It certainly is, and it's against the spirit of the lemon law and its consumer protections. And I say shame on the Attorney General's office.
Because now it's not as simple a process. Now you're asking these people who bought these cars unknowingly to now go hire a lawyer.
Correct.
Go through the whole process, for lack of a better word, be jerked around potentially in the state courts for 2, could be 3, 4 years. People just say, you know what, I give up. I'm tired. 'Cause
Precisely.
You just said before, in a previous show, that you need to preserve this car.
Correct. Absolutely. You still do.
Now, at the same time you're having this car, do you have to insure this car as it sits in your house?
Most folks have loans on their cars, and if you're going to drive it on any road, well, they might not be able to, but you have to maintain insurance. So you're having the cost of financing, the cost of ownership, the cost of insurance on a car that is not safe to be driven in many
Let's
cases.
say it's not even safe and you take it off the road. You brought up a good point. You now have a bank loan. The bank's going to say, essentially they don't care.
Well,
Does the bank, does that stop the loan?
that gets to be very complicated,
Or the
and it
lease?
varies from state to state. And some of my colleagues in other jurisdictions have had successful arguments that basically the defenses applicable to the dealer are also defenses applicable to the lender. It's this very interesting argument that can be made to help a consumer who may say, I have to stop paying for this car.
Well, I mean,
it may get repossessed, and I'm going to raise whatever defenses I have against the dealer also against the lender.
I guess you could also ask for a stay with the court. I don't know if that would be applicable anyway with the bank. Probably not. I'm going to say no.
I don't know. But again, unfortunately, New York has much weaker case law and statutes than a lot of our sister states.
Well, once again, we ran out of time for Legal Straight Talk. I want to thank Anthony again for stopping in and shedding some light and helping consumers. David versus Goliath. I hope everybody learned. By all means, you can always contact us at hlgny.com. And thanks you once again.
Thank you for having me in. I appreciate it. And likewise, anyone is welcome to call me. I have free consultations at my office. I have a website at my-lemon.net or 1-877-4MY-LEMON, or consumers are welcome to go to the website for the National Association of Consumer Advocates, of which I'm a member. And thank you very much. It was a real
Thanks
pleasure.
again.
Thank you.
Hi, I'm Jerry Parisi. Join Tom Mealy and Tommy Marr right here on Cablevision Channel 20 each week for an interesting episode of The Long Island View.